8:32 on April 30th, I call this meeting of the Joint House and Senate Subcommittee on Claims to order, noting that we don't yet have quorum. We will wait to take any votes until we do have quorum, which means that we will be skipping the approval of minutes, and then we will go from there. But just to start, this is one of the rare instances that House and Senate get together for a joint committee, and this is one of the rare instances that the legislature has a direct opportunity to provide justice to folks who may have had legitimate claims along the way. So as we're getting started, we'll just do a quick set of introductions around, and noting that there are no people to my right, the senators, so we'll let the Chair Quam introduce himself first.
Representative Quam, 24A, and my first one of these meetings was in 2011, so this agenda and everything are much superior to that one, and I anticipate we'll be able to do it under 4 or 5 hours.
Representative Frederick, I think this is my 6th year on the subcommittee here, and yeah, I'm with Representative Quam, and hopefully it takes less than that amount of time.
Maureen Sandy, Assistant Deputy Revisor and Counsel for the Subcommittee.
Jason Keenley, Deputy Revisor and Counsel for the Subcommittee.
Thank you, welcome all, and thank you to staff and researchers as reviewing the prior videos and subcommittees of this. Yes, it seems that we are just continually have an attitude of continuous improvement, and you have made this better and better for all involved. So thank you for your deep investment in time and process improvement. All right, with that, I'll turn to Mr. Keenley for agenda item number 3, summary of claims to be dismissed and those to be held over for informational purposes. For those, there'll be no outside testimony of the claims to be considered. Mr. Keenley.
Thank you, Mr. Chair. Because the dismissal requires a vote, I'll jump to the claims to be held over, which does not require a vote, and talk through those. There are several pending injury claims, and pursuant to subcommittee practices, the following injury claims are being held over pending maximum medical improvement, additional medical information, or upcoming release dates. And that's the Fraser claim, the Larson claim, the Schmidt claim, the Stewart claim, and the Washington claim. No motion is necessary for those holdovers. I'll also go through the pending property claims. Pursuant to subcommittee practices, the following property claims are being held over pending additional data requests from the Department of Corrections. That's the Lidberg case claim, the Rolbecki claim, and the Young claim. We do now have, well, I'll let you mention it.
Thank you, Mr. Keenley. Noting that we do now have quorum, we are formally in order. So we'll go back to the minutes.
Mr. Chair, I just wanted to note that there needs to be a correction to the minutes. The 2025 hearing began at 8:18 and not 9:18.
So I'm going to ask for a motion to approve the corrected minutes.
So moved.
Discussion on minutes or other updates? All in favor of the minutes, please say aye. Aye. Opposed? Minutes. Back to you, Mr. Keenley, item 3.
Thank you, Mr. Chair. We can now take up the dismissal claim. So in June of 2025, Ms. Pravali filed the claim against the Department of Human Services for compensation of funds that were liquidated from 2 irrevocable trusts established in 2011 by claimant's mother, Dorothy Guyan, and for related expenses. In 2019, Ms. Guyan's application for medical assistance long-term care services was denied by the Department of Human Services based on the department's application of Minnesota Statute Section 501C1206, which viewed the money in the irrevocable trust as assets for Ms. Guyan that needed to be expended before she would be eligible for medical assistance. Ms. Guyan appealed that decision to the Minnesota District Court, which found that Minnesota Statute Section 501C1206 was unconstitutional as preempted by federal law. Under controlling federal law, the money in the irrevocable trust should not have been calculated as Ms. Guyan's assets. The decision was appealed by the Department of Human Services and affirmed by the Court of Appeals. Ms. Guyan passed away before the district court hearing. Her daughter, Ms. Principali, as trustee, brought a claim for reimbursement of those expenses. Minnesota Statute Section 256.045 Subdivision 7 allows for judicial review by a district court of department decisions. In addition, the subcommittee rules prohibit claims for compensation for public assistance. A motion to dismiss this claim for lack of jurisdiction is necessary.
Thank you, Mr. Keenly. Any questions for Mr. Keenly before we move to a motion? Seeing no discussion, is there a motion to dismiss the claim? Moved by Senator Barr. Addition discussion. All in favor of the motion to dismiss, please indicate by saying aye. Aye. Opposed? It is dismissed. Thank you. We're on then to item 4. Next on the agenda is the 3 exonerated claims. Mr. Keenly will summarize each of the 3 claims. We will first hear the James Lamar Davis claim. Mr. Keenly.
Thank you, Mr. Chair. In 2015, claimant Davis was convicted of 2 counts of attempted murder and sentenced to 339 months in prison. The Great North Innocence Project filed post-conviction petitions and requested a hearing for violations of claimant's constitutional rights due to ineffective assistance of counsel. At the hearing, evidence was presented that claimant's counsel had not objected to material that the trial judge noted on the record as creating unfair prejudice, failed to move to strike testimony linking the claimant to an unrelated incident, and failed to call 2 witnesses who could have provided testimony to attack the credibility of the state's primary witness. In March 2020, claimant's conviction was vacated. The county attorney chose not to retry claimant, and he was released. In May of 2020, claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota Statute Section 590.11. In February of 2021, claimant's petition was denied on the basis that the convictions were vacated on grounds other than factual innocence. The decision was appealed. In October 2021, the Court of Appeals reversed the decision and remanded the case. The decision of the Court of Appeals was appealed to the Minnesota Supreme Court. The Supreme Court stayed claimant's case until final disposition of 2 other exoneration cases. The first case was decided by the Minnesota Supreme Court in May of 2022, and the second in May of 2023. The stay was lifted in August of 2023. Claimant's petition was granted by the District Court on June 5th, 2024. Claimant spent approximately 3 years in prison on the convictions while not serving time for other convictions. The claim was filed with the Minnesota Supreme Court. The court appointed a compensation panel. The state and claimant moved for summary disposition of a settlement totaling $250,000. $150,000 is for settlement for statutory damages, and $100,000 is for attorney's fees. The motion was granted, and hearing and payment are recommended.
Thank you, Mr. Keenly. Understand Peter Wold, the attorney for Mr. Davis, is here in person. If you're welcome to come to the dais and provide commentary and update. Mr. Wold.
Thank you. It's a pleasure and a relief to finally be here. It is quite a circuitous route to achieve even the result of being before you. As was heard, Mr. James Javon Davis was convicted, wrongfully convicted of murder. In 2015, he had been in custody for, I believe, over a year before that time, pending trial. Fortunately, the Innocence Project got involved and overturned that conviction. I was asked by his other counsel to get on board and be trial counsel for this process. Before getting involved in that case, I said I would only get involved if Mr. Davis would take a polygraph test on the issue of his absolute innocence. I know there's questions about polygraph, but his answer is important to be agreeable to take a polygraph test, and he readily agreed, and he readily passed that. We entered into the then process of establishing his innocence. The judge initially rejected the claim because he was not released from prison based on exoneration. He was released because ineffective assistance of counsel. The Court of Appeals and the Supreme Court, after a long time pending there, agreed that he could at least present his claim of innocence. We did that. We tracked down witnesses across the country and established an absolute alibi that Mr. Davis had at the time of this murder, and established to the district court in Hennepin County that he was absolutely innocent. That's not the end of the process. Then we deal with the Attorney General's office in going through the damages he suffered. Another process that led to mediation and was resolved by stipulation short of trial. A year ago, it was brought here at that time, but legislature or this group didn't have the time to hear that last year. So here we are. And I respectfully request that you grant this claim. It's a small measure of justice for a person that spent well over 3 years in the state prison for a crime he did not commit. I appreciate your consideration and applaud my client, James Jamal Davis, for surviving through this process. Thank you.
Thank you, Mr. Wold. Any questions for Mr. Wold or Mr. Keenly?
Mr. Chair, I have a question.
Go ahead, Senator Remover Baton.
Thank you. Apologies that I'm not there in person with you all right now. I have to finish pumping in my office before I can make it over to the meeting in person. But if you could just share, Mr. Wold, I was looking through the documents and I saw outlined a number of damages that started at 679,000. Could you just walk us through the process and how we got from that kind of initial number to the 250,000 claim that's before us today?
It's been quite a while, but I know there were issues that had been addressed with case law at prior times and made it difficult for Mr. Davis to qualify for certain expenses. I mean, there were issues like child support. He, I think, needed to pay. There was education expenses. There were things like that, and I just don't have that in front of me now, and I can't recall exactly. But through the negotiation process with the Attorney General's office and the threat of more time going to trial on those issues and so forth, it ended up as cases in civil situations often do, in a resolution that leaves nobody really happy. And that's what happened here.
Senator Barr.
Thank you, Mr. Chair. Mr. Wold, could you just kind of explain this one sentence here for me, please? It says, claimant spent approximately 3 years in prison on the convictions, which I'm assuming is the murder part, and then while not serving time for other convictions. Can you explain what the other convictions and what, if that has anything to do with this case, how that is, why that's in the summary?
I don't understand that, and I don't recall that. I wasn't part of that, his original case and what went on. I know that we had calculated over 5 years in prison, and he was held in custody, obviously, from when he was arrested and couldn't make bail till he had this trial that was totally inept. So I can't answer that question. I'm
Mr. Keenly?
Thank you, Mr. Chair and Senator Barr. The way the statute is structured for the exoneration claims, there is specific language that says the amount of time, because a person can be concurrently serving sentences for multiple offenses. So the statute is structured so that the calculation is any time served on that conviction and that conviction alone when other convictions are not being served. In this case, and I don't remember the details, there were a couple of trials that had happened sort of simultaneous to this other trial in other areas for shorter convictions. And so while the claimant served 5 years, the first couple of years of that, there were overlapping convictions from other trials that, and again, I could pull up the details and look through that. I don't have them off the top of my head, other than to say, when I was doing the research into the claim, there were other convictions not relating from this specific case.
Senator Barr.
Thank you. So just to make sure if there were, say, let's just say, for example, there were 2 charges, one was the murder and one was something else, convicted of both, serving time concurrently on both charges. The first charge is actually a conviction, the short one, and so we're only calculating the time on the leftover murder charge, correct?
Mr. Keenly.
Mr. Chair and Senator Barr, yes, that's correct.
Thank you.
Any additional discussion? Does a member have a suggested motion to approve? Representative Frederick.
I move the approval of the $250,000, Mr. Chair.
Thank you. Is there any additional discussion? All in favor, please indicate by saying aye.
Aye.
Opposed? Claim is approved. Thank you, Mr. Wold. Please give our thanks to Mr. Davis for enduring. We will now hear the next exonerated claim. The claimant is Clayton Douglas Grove. Mr. Keenly.
Thank you, Mr. Chair. In 2018, claimant Groves was convicted of 1 count of first-degree criminal sexual conduct and 3 counts of second-degree criminal sexual conduct. In the initial trial, claimant's motion to allow evidence of his accuser's prior false accusations was denied. Claimant appealed his convictions based on the denial of that motion. In 2021, the Minnesota Court of Appeals reversed the motion ruling. In 2022, claimant's conviction was vacated and a new trial ordered. In 2023, claimant was found not guilty on all charges. Claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota statutes 590.11. The petition was granted on June 24th, 2024. Claimant spent nearly 52 months in prison on the convictions. The claim was filed with the Minnesota Supreme Court. The court appointed a compensation panel. The state and claimant moved for summary judgment of a settlement totaling $350,000. $335,000 is the settlement for statutory damages. $15,000 is for attorney's fees. The motion was granted. Hearing and payment are recommended.
Thank you, Mr. Keenly. Is Christopher Sailors here or online? Mr. Sailors, would you like to comment or share additional information?
Yes, excuse me. I would. Thank you for having us today. I appreciate the panel's time and the consideration in this matter. I have had this case since 2017 when my client, Mr. Groves, was falsely accused of criminal sexual conduct. I had this case as a state public defender. And what we moved for what's called a parity motion to try to get the victim's confidential medical records. And we were denied. My client told me, I remember meeting with him in the jail about how she had made similar accusations about her father, exact same way. And the state, I believe, knew about these accusations. However, they acted like it was a fishing expedition and that we were just fishing for information to blame the victim and things along that nature. So we had the first trial. We lost the first trial. Mr. Groves went to prison on this matter. He appealed it, and that was through the state public defender's office. And that attorney was able to show that there was a need to get these records. The judge ended up reviewing these records in camera review, immediately granted a new trial after reviewing the records. And then he came back, got bail, posted that, and then we were given the records. And once I saw the records, it was scary almost. I had chills on my arm because it was the exact same accusation against her father that was not taken seriously. Same number of times that this had happened, same number of weird details, same number of things that just, quite frankly, couldn't have been true. It was almost identical. And so we had this information the second trial. The judge let us play the old statement about her father in totality, and it was compared next to the statement she made against Mr. Groves. Needless to say, in the second trial, it was an acquittal in probably about 30 minutes. So Mr. Groves was completely and totally exonerated by a jury of his peers after all the evidence was heard the correct way. The unfortunate part is he spent an absolute horrible time in prison, because when you go to prison and with an offense like this, with an alleged victim like this, your life in a prison is every single day you are fighting for your life, I could say. The assaults that he was in, the segregation that he had to endure because they needed to put him into protective seg, his post-traumatic stress disorder as a result of this, his just inability, even now, after it's been over now for 3 years now, his inability to relax and just be a normal person has forever been compromised. So this case, I've had this case for almost a decade, and I handled the exoneration claim with a couple of my colleagues in my private practice. And this case has been one case that I will never forget as long as I live, as a practicing lawyer, as the justice system doing someone wrong, but then the justice system sorting itself out. And then the turmoil that it takes on a human being to be falsely accused, serve a sentence, and have to live with the aftermath. This case also was the Minnesota Attorneys of the Year nominated myself and Benjamin Butler, the appellate attorney for the State Public Defender's Office, for the work that we did on this case. So this case is known in the Minnesota judicial system as an example of the system working, and I would say that that's true, but I will also say that this is also a huge example of the system failing Mr. Groves.
Thank you, Mr. Sailors. Any questions for Mr. Sailors? Senator Barr.
Thank you, Mr. Chair. Mr. Sailors, in the claim here, it says there's $15,000 for attorney's fees. You work in the public defender's office. The appeals court, you said, was the public defenders. Who's getting the $15,000 and why?
Well, I realize. Yeah, thank you. That's a great question. The $15,000 is the work that we did privately, filing the petition, negotiating the settlement with the Attorney General's office. There's a detailed bill we sent to the Attorney General's office to that end, and that's where that money came from. It has no work of the trial work, the appellate work. All of that money is on the state of Minnesota because he qualified for the state of the public defender's office. That's why that amount is far different than the amount asked in the case previous.
Thank you, Mr. Sailors. Other questions or discussion? Seeking a motion to approve the claim. Is there a moved by Senator Barr? Is there additional discussion? All in favor of approving Clayton Douglas Groves' claim, please indicate by saying aye.
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 Opposed? Claim is approved.
Thank you, honorable panel.
Thank you, Mr. Sailors. Please express to Mr. Groves our heartfelt apologies and hope that he finds a bit of rest with this.
I think it will definitely be the step in the right direction now that it's finally over. Thank you, everyone that listened to his case and considered his matter.
Thank you, Mr. Sailors.
Have a good day.
We will hear the final exonerated claim for this meeting, the Marvin Haynes claim. Mr. Keenly.
Thank you, Mr. Chair. In 2005, claimant Haynes was convicted of 1 count of first-degree murder and 1 count of second-degree assault. Claimant was 16 years old at the time of the conviction and was sentenced to life in prison. The Great North Innocence Project filed post-conviction petitions and requested an evidentiary hearing. At the hearing, new evidence was presented that the conviction had been procured based on false evidence and unduly suggestive eyewitness identification. After the evidentiary hearing, the state agreed that the conviction should be vacated and all charges dismissed with prejudice. In 2023, claimant was exonerated when the county court vacated his convictions. Claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota Statutes 590.11. The petition was granted on September 12, 2024. Claimant spent 19 years, 6 months, and 23 days in prison on the convictions. The claim was filed with the Minnesota Supreme Court, and the court appointed a compensation panel. The state and claimant moved for summary disposition of a settlement totaling $4.5 million. The motion was granted. Hearing and payment are recommended.
Thank you, Mr. Keenly. Is Attorney Aaron Scherzer available? No. Discussion for the committee. I'll comment this, to note, as Mr. Keenly said, the claimant was 16 years old and then spent 19 years in prison, and the formative years of his life were terribly altered. And yes, is there a motion on Mr. Haynes's claim? Representative Frederick.
Mr. Chair, I move for the $4.5 million approval.
Representative Frederick has moved approval of the Marvin Haynes claim. Is there additional discussion? All in favor of the Marvin Haynes claim, please indicate by saying aye.
Aye.
Opposed? The claim is approved. Moving on to item 5 of the agenda, injury claims. Next on the agenda is the Department of Corrections injury claims. The first injury claim is the Arnold Baker claim. Mr. Keenly, could you summarize the claim, please?
Thank you, Mr. Chair. Claimant Baker asked for compensation for an injury occurring while performing assigned duties. Claimant slipped on ice while carrying wood. Claimant was referred to health services with pain in his ankle and soreness in his knee. Medical records show that after the fall, claimant had varying degrees of persistent soreness and pain, but lacked documentation showing any compensable ankle or knee injury. The department submitted substantial information relating to pre-existing conditions that claimant may have suffered from. However, because there is not a compensable injury, none of the pre-existing condition information is responsive. There is insufficient evidence that claimant has a permanent compensable injury. Hearing and denial are recommended.
Thank you, Mr. Keenly. Is there discussion? Seeking a motion on this claim to approve or deny. Is there such a motion? Senator Barr.
I move to deny the claim.
It's been moved to deny the claim by Senator Barr. Is there additional discussion? All in favor of denying the Baker claim, please indicate by saying aye.
Aye.
Those opposed? Motion carries. Mr. Keenly, could you, the second and final injury claim we'll hear today is the Mark Carroll claim. Mr. Keenly, please summarize the claim.
Thank you, Mr. Chair. Claimant Carroll asked for compensation for an ankle injury that occurred while performing assigned duties. Claimant was working with a crew clearing trees and brush when he fell and injured his ankle. Claimant was transported to the hospital for emergency care, and x-rays revealed that claimant had suffered a closed trimayoral ankle fracture. Medical records show that claimant's ankle healed well with only minimal impact to functions rateable under Minnesota Rules Part 3223.0520 Subpart 4. Claimant has a permanent partial disability under the Workers' Compensation Schedule in Minnesota Rules Part 5223.0520 Subpart 3, Item D. Claimant suffered a trimalleolar, got it that time, fracture. A trimayoral fracture is rated at 4% of the whole body. Because the total disability is less than 5.5%, compensation is calculated as 4% times $114,260, which equals $4,570.40. Hearing and payment are recommended.
Thank you, Mr. Keenly. Is there discussion before we move to a motion? I'll seek a motion to approve or deny. Senator Barr.
I move the state pay the claimant in the amount of $4,570.40.
Thank you, Senator Barr. Senator Barr has moved approval of the Mark Carroll claim in the amount of $4,570.40. Is there additional discussion? Moving to vote on the claim. All in favor of the Mark Carroll claim, please indicate by saying aye. Aye. All those opposed? The claim is approved. All right. Next item on the agenda is the Department of Corrections property claims. We'll first take the claims that have been recommended for hearing by council, and then ask for any claims the members would like to hear. Ms. Sandy will first summarize claim number 11 on the agenda, the Anthony Edwards claim. Ms. Handy.
Thank you. Claimant Anthony Edwards files a property claim of $161 for food, a J-Pay tablet, and Adidas shoes. On May 2nd, claimant was transferred to a restrictive housing unit, and the Department of Corrections staff inventoried and packed claimant's property. The property report from the backup shows claimant's tablet was in working condition. The property report includes the Adidas shoes as claimant's authorized property, but indicates staff did not pack the shoes. The record does not include an incident report or a disposition record, so there is no indication of what happened with the shoes. The department offered claimant $70 to compensate for the shoes, and claimant declined this offer. On June 2nd, claimant retrieved his property, and there is no record of claimant reporting his tablet as not working or of his shoes as missing until June 6th. The food items claimed are canteen items, which are not tracked by the department because they are easily consumed, shared, or traded. As such, there is no evidence of what food was still in claimant's possession when the staff packed claimant's property. As the record shows, the department recognized staff's responsibility for the claimant's missing Adidas shoes. Council recommends a hearing for the property claim and reoffering payment for claimant's lost shoes. Council recommends denial of the claim for the food and the tablet.
Thank you, Ms. Sandy. Is there discussion on the Anthony Edwards claim regarding shoes, food, and a tablet? Senator Umar Verbay.
Thank you, Mr. Chair. I would just like a little bit more information about the tablet claim. I am pulling this information up on my computer right now, but I remember reading more about this last night. Is there a reason why there's a recommendation not to pay for the claim for the damaged tablet?
Ms. Sandy?
I think, according to the record, it was not reported as not working when it was packed by staff. And usually in the process, when staff is packing claimant's properties, they're noting in the report whether or not the item is present and whether or not it's in working condition for all the electronics. When it's not working, they will confiscate it and record that in an incident report or a disposition property report. And then once claimant retrieves their property, they have within 24 hours to report anything as missing or not working before they then take it into their possession.
Senator Umar Verbay.
Thank you, Mr. Chair. I know there's been some difficulty with tablet access in the Department of Corrections, so was the claimant able to receive a new tablet?
Ms. Sandy or Mr. Keenly, or I believe we have a guest testifier who may be able to provide additional information. Please introduce yourself for the record and then respond to the question.
Thank you, Mr. Chair, members. John Lauer, Acting Deputy General Counsel for the Department of Corrections. Currently, the department does not have the tablets that we are allowing the IPs to purchase, incarcerated persons to purchase. We've been having some difficulties with contracting and getting ADA compliance on tablets. So currently, there are no tablets available for purchase for incarcerated persons. They were, they were allowed to continue using JPay tablets as like a grandfathered in. But once those tablets stop working, we are unable to replace them.
Senator Umar Verbay.
So this person purchased the tablet, didn't have an ability to get a new tablet because the Department of Corrections has this ongoing issue with getting ADA compliance with JPay.
Mr. Lauer.
Yeah, and we've been working with a number of vendors to try to get a new system in place for that, but currently no.
Thank you, Mr. Chair.
Senator Umar Verbay.
Yeah, I'm aware of that issue. I just think as that's outstanding, I would suggest that we cover the expense of the tablet.
Ms. Sandy, do you have an amount of the tablet was claimed for?
I'd have to look through, but I don't see the specific amounts for tablets, and I know the department has a list of amounts that are attributable to tablets. I will note that for the tablet that they have in their possession, we would be compensating for saying that that tablet was missing or not present. And I think according to the records from staff, it shows that it was present, or we can't account for what happened to it. So if you were recommending for a new one, it would be outside of this claim. It would be wanting a new tablet. And I'm thinking that the claimant's kite might have $75 for the JPay tablet.
Senator Uma Verbatim.
Thank you, Mr. Chair. And again, I remember reviewing this in a few other cases with tablets, but just trying to get clarification. Does the person currently have access to the tablet that they paid for? Because if they do not have access to it, I think they should be compensated for it because there's no ability to receive a new tablet. If they do have access to this tablet, I think that's a different situation.
In this case, paragraph 2, on June 2nd, claimant retrieved his property, and there is no record of the claimant reporting that his tablet was not working. So, Ms. Sandy, is this, in this instance, that they reported that it is broken and unable to be used?
I think I'll leave that for the department to verify if he still has the tablet.
Mr. Lauer.
That's not working.
Thank you, Mr. Chair and members of the committee. I don't have any information that this incarcerated person does not have the tablet anymore. It was returned to them. As far as staff were able to tell, it was in working condition when they returned it to him.
Senator Uma Verbatim.
So the person does have access to the working tablet, or you're unsure?
Mr. Lauer.
Thank you, Mr. Chair and members of the committee. I haven't been able to check in on that specifically, but at the time that it was returned to him, staff indicated that it was working, but I have not independently verified that since we submitted this information to the subcommittee.
So, Mr. Lauer and Ms. Sandy, let's see if I have this understanding correct. The timeline that the claimant received his property back was on June 2nd, and then on June 6th, he reported that the tablet, which was part of that property, was not working. Ms. Sandy?
That's correct. Yep.
Representative Quam?
Thank you. Having, over the years, had older tablets and has had them stop functioning, I understand the 24-hour rule in case the cause was because of the storage and handling, et cetera. But I would move to deny the claim because things stopped working. If it had been the problem of the storage in the possession of the prison, then he had 24 hours. If it stopped working, apparently the dates indicate it was greater than 24 hours, so therefore I would move to deny.
Representative Quam, noting that your motion, is that only on the tablet, or there's also a shoe claim and a food claim?
Well, the tablet
Okay,
would be
tablet.
the thing that we want to decline.
Okay.
So we can move on to deciding what we should do with the other stuff.
All right, thank you. Representative Quam has made a motion regarding only the tablet to deny payment of the tablet. Is there additional discussion? Senator Uma Verbatim.
Thank you, Mr. Chair. I think if we have confirmation from the department that the person had access to a working tablet after making this claim, I'm comfortable moving forward not compensating for that. My concern with any of these claims is if after transfer someone received a damaged tablet, doesn't have any ability to either receive a new tablet or receive compensation for what they initially purchased.
Representative Quam.
That would be outside the purview of the Claims Committee. We are restricted to the guidelines and precedents have been set before unless the committee decides as a whole to decide that precedence means nothing. And I think it's important to focus on what we're here to do is ensure justice and appropriately compensate for issues, not to stray from the process.
Senator Uma Verbaeten.
So I'd be comfortable moving forward, just the claim for the shoes. I believe the recommendation is not to pay for the food claim as well. Does that satisfy Representative Quam?
So I would accept amendment to my motion to compensate for the shoes.
Representative Quam has modified his motion to provide compensation, to approve the claim for the shoes in the amount of $70 and to deny the claim for food and the tablet. Is there additional discussion? Representative Frederick.
Thank you, Mr. Chair. I want to say that I agree with this. I think the question regarding the tablet, because my understanding of this is the tablet was confiscated. At the time, it was verified that it was working. The tablet was given back to the claimant, and he had, I forget, the 24 hours, 48 hours to say whether or not it was or was not working. He did not report anything during that time frame, which would have given him an avenue to seek compensation, and I think that would have been the appropriate time to do so. And then it was outside of that time frame that he said is no longer working. So I don't think that I would support additional money for the tablet for that reason. So I would support the motion.
Mr. Keenly.
Thank you, Mr. Chair. And just to give the subcommittee a little bit of background on this, when a person picks up their property, they are given an opportunity to go through and test everything. There's a station there. You can, if you would like to take, well, I won't say that the Department of Corrections will give you tours, but they've given tours in the past of property divisions of what that area looks like. When they get their bins back, there's a place that they can plug in their tablets, their TVs to make sure that they are functional. Again, sometimes they choose not to do that, and then that may be a situation where we got here, but they're at least given that opportunity and the availability of an electrical outlet, the things that they need in order to test those when they pick up their property.
Thank you, Mr. Keenly. Any additional discussion? Seeing no additional discussion, we will move to act on Representative Quam's motion to approve the shoe claim and deny the food and tablet claim. All in favor, please say aye. Aye. Opposed? Representative Quam's motion is approved. All right, the next claim recommended for hearing is Claim 16 on the agenda, Mr. Griffin's claim. Ms. Sandy will summarize that claim. Ms. Sandy.
The next claim is claimant Terrelius Griffin files a property claim of $145 for a damaged JPay tablet. On July 30th, 2025, claimant was transferred to a restrictive housing unit, and the Department of Corrections staff inventoried and packed up claimant's property. Staff noted on the property report that claimant's tablet was packed and that it was working. Claimant retrieved his property on August 19th and informed staff that his tablet was broken. Staff filed an incident report stating that the tablet was working when packed, but was no longer working because the lithium battery expanded. The incident report also notes that staff gave the tablet to the property department to dispose of it. The record includes the property disposition report dated August 22nd, with a note that staff was disposing the tablet because of the expanded battery. According to the record, the department argues that the cause of the damage is due to other factors, such as the manufacturing defect, aging and degradation, or some other pre-existing physical damage. While it is unclear what specifically caused the damage to the tablet, it is clear that the damage occurred while the tablet was in the custody of staff. There is a question of whether the conditions of this claim amount to staff being held responsible for the damage to claimant's tablet. Council recommends a hearing on the property claim but makes no recommendation about the payment.
Thank you, Ms. Sandy. Is there discussion? Senator Uma Verbaeten.
Thank you. I think this is where I'm understanding the two different tablet cases that I was reviewing. So in this case, the claimant did report that damage in the 24-hour time period. That's correct.
That is correct.
Then I would recommend covering the cost.
Senator Uma Verbaeten has made a motion to approve the Torelius Griffin claim. Is there additional discussion? Representative Quam.
Thank you. I was wondering if at some point we can find out from the agency the storage, because if there's, humidity and other issues, it might be prudent for them to take the actions to prevent possible issues. Thank you.
Thank you, Representative Quam. Mr. Lauer, yeah, could you comment on that? As we know, we can't pack, batteries like this into, the underbelly of a plane because it might expand and then burst into fire. I would have the same fears that I think Representative Quam is envisioning in his head. Can you describe the storage?
Mr. Chair, members of the committee, at MCF Stillwater, the storage room is in the basement of the facility. I've been in there several times. It's relatively cool. Stone walls. I personally have not heard of this happening before. I've been with the DOC for about a little over 4 years. And this is the first situation that I've heard of a tablet expanding in storage. I can only speculate as to why this occurred. It could be due to the age of the device or I guess any number of factors. But I don't know about the humidity in the basement at MCF Stillwater, but I have been there several times and it's relatively cool.
Mr. Lauer, I will note in the Griffin claim on page 3, the handwritten description, it states, every staff member knows that there is no AC in Stillwater and the temperature reaches 120 degrees or hotter where the electronics and tablets were stored. And noting that the storage was July 30th through August 19th, I guess I give a little bit of, I understand how my basement slowly heats up through the summer. So I don't want to question when you visited the storage facility, but it may be different in different seasons of the year. Mr. Lauer?
Mr. Chair, members of the committee, I have visited in the summer, and it does get very hot in the upper levels of the facility. I don't think that the basement of the facility was really comparable to the heat that was above ground, and I think that, as you mentioned, that is pretty common in basements in Minnesota. However, I don't know the exact temperature of the storage area.
Thank you, Mr. Lauer, and perhaps noting with the Stillwater prison closing, that it will be, we won't need to contemplate this as much longer. Additional discussion? Additional discussion? The motion is to approve the Torelius Griffin claim. All in favor, please indicate by saying aye. Aye. Opposed? Claim is approved. The next claim recommended for hearing is Claim 22 on the agenda. The Artesi-Kennard claim. Ms. Sandy, if you could please summarize the claim.
Claimant Artesi-Kennard files a property claim of $67 for damaged Reebok shoes. On June 17, 2025, claimant was transferred to a restrictive housing unit, and Department of Corrections staff inventoried and packed up claimant's property. During this pack-up, staff confiscated claimant's Reebok shoes and put it on a property disposition record because the shoes were not listed on claimant's property report. Staff later confirmed claimant's ownership of the shoes and attempted to return them to claimant. Claimant refused to accept the shoes because the shoes now had red splatters on them. Claimant stated he was afraid staff would confiscate the shoes later because they appeared altered with the red stains. Staff confirmed that the stain seemed to be from Kool-Aid droplets and offered to include a note on this on claimant's property report. But claimant refused to accept the shoes and filed this claim instead to request a refund for a new pair of shoes. There is a question of when the red staining got on claimant's white shoes because the condition of these shoes were not noted until after they were in the custody of staff and claimant reported it. The department provided some additional information that might have gotten to the packet with pictures of the shoes showing the red staining. They provided additional information, and in viewing those pictures, there is a question of whether this staining constitutes damage that requires compensation. So council recommends a hearing on the property claim, but makes no recommendation on the payment.
Thank you, Ms. Sandy. Is there discussion? Is there a motion? Senator Barr.
I move to deny the claim.
Senator Barr has moved to deny the claim. Is there additional discussion? All in favor of denying the claim, please indicate by saying aye. Aye. Those opposed? Claim is denied. The next claim recommended for hearing is Claim 28 on the agenda, the Hassan McKeever claim. Ms. Sandy, if you could summarize the claim, please.
Claimant Hassan McKeever files a property claim of $232 for a disposed TV. On February 10th, 2025, claimant was transferred to the Restrictive Housing Unit, and Department of Corrections staff inventoried and packed up claimant's property. Staff noted in claimant's property report that claimant's TV was present and it was in working condition when staff had packed it. Staff authored an incident report from the pack-up, and the report states that all of claimant's electronics were in working condition. On February 11th, claimant retrieved his property and notified staff that his TV was broken. Staff added a note to claimant's property report stating that the TV was broken and confiscated the TV for disposal. Staff noted the confiscation in an incident report, which staff noted that the TV was being held pending disposition, and they documented this on the property disposition record. The disposition record states that the screen works, crack in housing, and used for sparking. According to the department's memo, and as noted in the first incident report and disposition record, claimant's TV worked, but it was confiscated for being altered. If staff had noticed the crack in the TV at pack-up, it would have been clear that this damage was caused by claimant. As staff did not report the damage and confiscated the TV during the pack-up, they did not report the damage and confiscate the TV during the pack-up. There is a question now about when the damage occurred, as it was only noticed after claimant retrieved the TV from staff. As the department describes the damage as being caused to sparking, the department implies claimant may have caused the damage by altering the wiring in the TV at some point before the pack-up. So council recommends hearing the property claim, but makes no recommendation about payment.
The subcommittee have discussion on Mr. McKeever's claim. Representative Frederick.
Thank you, Mr. Chair. I think that this highlights the importance of good documentation by staff when they're packing up any sort of property. And I think that's the question of when was it done. I think it is quite possible that it was done prior to the packing up, but we don't know that. And because it's not documented that way, I would support payment of the claim.
Senator Umo Verbaeten.
I would agree with that outstanding question. I also just wanted clarification on, I was understanding the damage to be like a crack in the TV, but then the explanation from the department being that this damage may have been from the way it was being used and the cabling, I believe, that would have gone into the TV. Can you just clarify that information for me?
Ms. Sandy.
Sure. I'm looking at the department's memo. And it describes that they think that's what's caused the cracking because of a sparking, which is when you mess with the wiring to cause some kind of electrical surge. But they did not notice that when they packed up the property, and they're supposed to note any kind of damage, so the crack, this should have been noted evidence of sparking should have been noticed or notified in the incident report or in the property report and then disposed of at that time, but neither of these things were done.
Senator Uma Verbaeten.
Thank you, Mr. Chair. Thanks for the explanation. I think it's also possible that a crack could have happened through another form of damage. I think we just are unsure. So I would support Representative Frederick's motion.
So I believe the motion on the floor from Representative Frederick is to approve the McKeever claim. Did I interpret that correctly, Representative Frederick? Thank you. Is there additional discussion? All in favor of the McKeever claim, please indicate by saying aye.
Aye.
Those opposed? Motion carries. McKeever claim is approved. Next claim recommended for hearing is claim 39 or 29 on the agenda, the Alberto Palmer claim. Ms. Sandy, if you could summarize the claim.
Claimant Alberto Palmer files a property claim of $176 for missing Nike and Adidas shoes and headphones. On September 16th, 2024, claimant was transferred to the restrictive housing unit, and Department of Corrections staff inventoried and packed up claimant's property. Staff noted claimant's shoes and headphones as present on the property report, but not packed by staff. Staff filled out an incident report which notes that claimant was over his 2-bin limit. Staff placed items that were confiscated on the property disposition record and noted that the shoes were confiscated because they were not on the list, and the headphones were confiscated because they were altered. Claimant filed a complaint about the confiscation in a kite dated September 18th and provided information about the purchase of his shoes, stating that the shoes had been on his property report, unlike what staff noted on the disposition record. Staff responded and told claimant to work with property staff after he got out of segregation. Claimant got out on November 25th, but staff had already disposed of his property on October 22nd. Claimant filed a kite on December 11th and asked staff to remove the headphones from his claim. Regardless of this request, DOC policy requires that the disposal of altered property because it's considered contraband. According to the department memo, the department argues that claimant failed to inform staff about how to dispose of his property within the 30 days time period after he was notified about the confiscation. There's a question about how to interpret staff's response in the kite, which directed claimant to wait, and a question of whether the confiscation of the shoes was appropriate. The record seems to indicate that claimant's shoes were mistakenly confiscated and should not have been disposed of by staff. So council recommends a hearing on the property claim and payment for the shoes.
Thank you, Ms. Sandy. So to be clear, the items in question here are a pair of Nike shoes, a pair of Adidas shoes, and headphones. Which I think is the first line of the cover page. Claimant Alberto Palmer files a property claim of $176 for missing Nike and Adidas shoes and headphones.
I want to verify about between the two shoes, because I believe it's only the one shoes that was improperly taken and then later verified to belong on the property report.
Mr. Chair,
Senator Uma Verbaeten.
were both shoes and the headphones initially on the property list or just the shoes?
We'll combine.
Senator,
Ms. Sandy?
on the property report, it's listed the Nike shoes are there and the Adidas shoes are there on the property report, dated.
What's the page number at the bottom, Ms. Sandy?
Page numbers, it says 1 out of 2 or 3, but it doesn't have I think it's page 10. Actually, page 8.
Ms. Sandy?
So on page 4 of the staff's response to claimant's kite, in response to claimant arguing that his shoes were supposed to be on his property report and he provided proof of the purchase receipts, the staff said to work with property staff when you get out of segregation, which would have been past that point when they had already disposed of it.
So, Ms. Sandy, to be clear, it's claimant McKeever is, it is 3 items, missing Nike and Adidas shoes and headphones. Appears, he's claiming the Nike for $76, the Adidas for $60, and the headphones for $40.
That's correct. I believe the headphones are not included in the recommendation because they were confiscated for being altered. And by policy, that wouldn't be compensated for.
Thank you, Ms. Sandy. Is there additional discussion? Is there a motion? Senator Barr.
I move we pay the claim of $136, the 2 shoes and not the headphones.
Senator Barr has moved that we approve the claim for the 2 pairs of shoes in the amount of $136. Is there additional discussion? All in favor of approving the claim in the amount of $136, please indicate by saying aye. Aye. Opposed? Claim is approved. Final claim recommended for hearing is claim 31 on the agenda, Jeremy Richardson claim. Ms. Sandy, if you could summarize the claim, please.
Claimant Jeremy Richardson files a property claim of $175.25 for missing clothing, shoes, and miscellaneous items. This claim covers claimant's 3 transfers to the restrictive housing unit and the packing of his property by Department of Corrections staff between October 28th and December 26th in 2024. On the first transfer in October 28th, staff noted on the property report that claimant's state-issued clothing was over the property limit. The record shows claimant's beard trimmer was present, but doesn't indicate whether it worked. The incident report includes notes that staff found a bag of wet clothing and disposed of it. On the second transfer on December 7th, staff noted on the property report that claimant's beard trimmer and state-issued clothing were missing. The incident report indicates staff confiscated claimant's completed hobby crafts as contraband. According to the department memo and the intake form, property report, and the incident report from this transfer, claimant notified staff about some missing clothing, and staff agreed that claimant was missing a gray shirt and a pair of shorts. On the third transfer on December 26th, staff noted on the property report that claimant's beard trimmer was missing and that his state-issued clothing were all present. Because staff acknowledged claimant's gray shirt and shorts were missing while in staff's possession, the department offered claimant $18.40 as compensation, but claimant denied the offer and filed this claim instead. Besides the property that staff verified as missing, the items in this claim were either disposed of as contraband, missing while in claimant's possession, not missing per the last property report, or were from the canteen and therefore not tracked. There's insufficient evidence that staff action or negligence is responsible for that missing property. Council recommends hearing and reoffering the $18.40 for the missing gray shorts and shirt that were acknowledged by the department staff.
Thank you, Ms. Sandy. Is there a discussion or questions for Ms. Sandy? Is there a motion? Senator Barr.
I move that we pay a claim $18.40.
Senator Barr has moved that we pay the claim, the Richardson claim, in the amount of $18.40, which matches the gray shirt and shorts claim. Is there a discussion? All in favor of paying the Richardson claim in the amount of $18.40, please indicate by saying aye. Aye. Opposed? Claim is approved. That is the end of the list that council has recommended that we hear. If there are any other property claims that council has not recommended for hearing or holdover that members would like to bring up, this is the appropriate time to do so. So noting that on pages 4 and 5 of the agenda, there are additional claims that council has reviewed and per practice and is recommended to not hear. It's then our job to indicate if there's any that should be pulled out and taken a longer look at. Not hearing any, I'll ask if a member could make a motion to dismiss the remaining claims or a motion to hold some over if there's questions. Senator, Representative Frederick.
I'll move to dismiss.
Representative Frederick has moved to dismiss the remaining claims. Is there any additional discussion? All in favor of the motion to dismiss, please indicate by saying aye.
Aye.
Opposed? Motion carries. The remaining claims have been dismissed. If there is no other business before the subcommittee, then this meeting is adjourned.